everyone. Imagine you live in a hostel and the warden puts up a furious notice on the bulletin board. No making instant noodles in the hostel rooms after 11 p.m. The next night at midnight, the warden catches a student happily boiling pasta and reheating butter chicken. The student looks the warden dead in the eyes and says, "Ma'am, the rule clearly says noodles. This is penne and pasta, entirely different grain structure." If the warden is a literalist judge, the student walks free. But if the warden uses common sense, they will ask, what was the actual nuisance, the noodles or the late night cooking waking everyone up? Today we are breaking down the mischief rule of interpretation. The mischief rule helps determine the intention of the legislature in making a law. It directs the court to look into the mischief, suppress the mischief, and advance the remedy. It is popularly known as the Hayden's case or the Hayden's rule. Before you go into and understand the four principles that emanated from the Hayden's case, you have to understand the distinction between common law and civil law. Let us suppose that you are making masala dosa. To make the masala dosa, in the first scenario, you look into the old recipes, you will ask your parents, and then you prepare the masala dosa. That is an example for common law, which permits modifications as well as innovations. In the second scenario, you look into one single recipe and you follow word by word. That is nothing but the civil law. So, mischief rule is a product of common law. So, the first principle that emanated from the Hayden's case was what was the common law before the law came into existence. The second one will be what was the mischief that was sought to be addressed in the statute. And the third one would be what was the way in which mischief was suppressed. And then how did the parliament advance the remedy? Let me make you understand using a simple illustration. A movie theater issues a strict policy. No outside food or drinks in containers are permitted inside the cinema hall. A customer walks into the hall carrying two large fresh pineapples in their hands, no plastic bag, box or container. When stopped at the door, the customer argues, "I complied with the text. These are just raw fruits and they are not in a container." Now, how do we apply the mischief rule and the four steps in mischief rule? The first one is to address what was the prior rule or law before the notification came into existence. The customers could bring anything inside, which led to messy seats, strong food odors, loud chewing noises. Then the next would be to address what was the mischief. The mischief would be that the fellow viewers would get disturbed by the smelly, messy and noisy food, and also litter on seats and carpets made sure the memories turned out to be disturbing. The third would be what was the remedy provided. The remedy was that the circular clearly banned people from carrying external consumables into the screening hall. Now, what was the true reason behind the remedy? To keep the cinema hall clean, quiet and odor free during the shows. This is the way in which we substantiate the four principles that emanated from the Hayden's case to day-to-day examples. Now, let us apply the same test even to interpret a particular statute. Let us take Section 4 of Equal Remuneration Act of 1976 into consideration. Section 4 states that an employer cannot pay unequal remuneration to men and women workers performing the same work or work of a similar nature. The issue before us would be the female stenographers and confidential assistants in an airline company were paid less compared to the male counterparts. The employer argued the terms of their appointment letters and contract labels are different. So technically, the employment positions were different. Now, how do we apply the four principles which emanated from the Hayden's case? The first would be, what was the prior law? That is, the employers had unrestricted restriction to pay women lower wages than men for doing the same work by changing job titles or contract wording. The second would be to identify the mischief. The mischief would be that gender-based wage discrimination and economic exploitation of female employees. The third would be, what would be the remedy suggested by the parliament? The remedy will be interpreting Equal Remuneration Act and the provision to mandate equal pay for substantially similar labor regardless of gender. Now, how did the suppression of mischief happen? The courts will look into the actual nature of the work performed, not job titles, contract semantics, or minor cosmetic differences. Now, if we contrast with literal rule, the employer escapes by pointing out technical differences in job titles. If we apply the mischief rule, the court will rule in the favor of female workers because cosmetic distinctions cannot defeat Parliament's clear intention to eliminate gender pay disparity. Now, let us look into Hayden's case. Imagine I own a house and I give you a lease for 10 years. While your 10-year lease is still running, I give the same house to your friend for another 80 years. Can I create a second long lease while the first one is still alive? Yes, please tell me the answer. Excellent. Now imagine the landlord is a 16th century religious institution. The government is about to take over its property and the institution suddenly starts giving ridiculously long leases to its rents. That was essentially the mischief Parliament was worried about in Hayden's case. The College of Otley held certain lands. Some of these lands were already occupied under existing interests, in particular where the father and where the son held copyright interests for their lives. Despite those existing interests, the warden and the canons granted Hayden a lease for 80 years over the land. And here is the important part. The existing interests had not ended. The college subsequently surrendered its possession to King Henry VIII. Now, Hayden was claiming an interest in the land under this long lease. The Parliament had already become concerned about what religious institutions were doing with their property. The Statute of 31, Henry VIII, dealt with leases granted by religious houses. The concern was essentially, if these institutions know that their property is going to be taken over, what stops them from giving away enormous long-term interests before that happens? And that was the mischief. The court explained that before the act, religious bodies could make leases for as many years as they wished. The mischief was that, anticipating dissolution, they could make long and unreasonable leases. Now, what was the loophole? The Parliament wanted to prevent institutions from creating these overlapping interests to defeat the purpose of legislation. Here, the Parliament ended up enacting an act called as Abolition of Religious Houses Act. Because of this act, all the land owned by the church now belonged to the crown. Now, you would want me to answer, why did the parliament create this law in the first place? Here, the parliament created this law to prevent a situation called as doubling of estates. Now, how did the four principles get applied in the present case? What was the common law before the Act? Before Parliament intervened, could religious institutions grant long leases? Yes. The common law permitted religious and persons to make leases for as many years as they wished. Now, what was the mischief? The problem was that religious institutions, anticipating dissolution, could grant long and unreasonable leases. This could effectively tie up the property and defeat the Crown's interests after dissolution, that is, after the promulgation of the Act. Now, what was the remedy the Parliament provided for? The Parliament responded through the Statute of 31, Henry VIII. The statute dealt with leases made while existing estates or interests in the land were still continuing. The idea was essentially, don't create another competing long-term interest while an existing interest is still alive. The court understood the statutory remedy as preventing the creation of these overlapping or doubling of estates. Now, what was the true reason for the remedy? This is the heart of the case. The court reasoned that there was no sensible reason for the institution to create a fresh long lease while an earlier estate or interest was still continuing. The purpose was to prevent the doubling of estates and evasions that could defeat Parliament's intention. Students, imagine you go to a doctor. The doctor gives you medicine. You don't understand the medicine merely by the label. You ask, what disease was this medicine meant to cure? This is exactly what Hayden's case tells a judge to do. Don't merely read the statute. Find the disease, the mischief, and then interpret the statute so that the medicine, the remedy actually works. Now, we will come to Smith versus Hughes case. The Queen's Bench Division delivered another judgment by applying the mischief rule. Now, this was a case which involved prostitutes and section 1 subsection 1 of Street Offences Act of 1959, where it was clearly provided that soliciting in a street or public place for the purpose of prostitution would be an offense. Now, what did the prostitutes do here? They clearly told that in the act it was given that the solicitation in a street was prohibited. But what they were actually doing was they were trying to solicit from the balconies or the windows. So that they also stated that they were away from the street and that is where the prostitution was happening. Now, how did the courts apply the mischief rule and the four principles? What was the common law before the passing of Street Offences Act? The common law was that anyone or any woman would actually solicit people from decent localities through ways like hissing, etc. And what is the mischief that the common law did not provide for? The mischief was that solicitation in a decent locality. And how did the Parliament remedy this following mischief? By passing Street Offences Act of 1959. And that's why the prostitutes were not given any relief, because Here, the whole point of coming up with this enactment was to prevent women from soliciting people in decent localities, which are meant for civic living and civic sensitivities. If I have to bring in a modern way of looking into it, you can bring right to privacy into consideration, and the prostitutes could say that whatever they were doing was within privacy, and they could also say that it was right to use the body or the anything as such for the purpose of earning money or anything that would amount to right to freedom of trade, occupation and profession. That could be the way in which they could argue the matter, provided the same facts happen in the contemporary world. But back then, this was an offense. Now, let us move on to crockery versus carpenter. In this, Licensing Act of 1872 was brought under surveillance. Here, the Act clearly stated that it would be an offence to be drunk in charge of a carriage on a highway. So now what did Mr. Crockery do? What Crockery did was he rode a bicycle while being drunk, and he pleaded that a bicycle was not a carriage on a highway. A carriage would mean that which is run through horses and things like that. So this incident happened during the 1872 when there were no modern ways of means of transportation like bikes, things like that. So here, applying the mischief rule, the court held that the word carriage would include even bicycles. So the way in which mischief rule was applied here was what was the common law before the matter came into existence. The common law was that to prevent people from drinking and driving, this law stated that it would be an offence. Now, what was the mischief? The mischief was drinking and driving. And now, how did they suppress the mischief? They suppressed the mischief by bringing in the Licensing Act of 1872, which stated that somebody being drunk in charge of a carriage on a highway would be prosecuted for an offence. And a bicycle basically fell within the ambit of carriage. This is how we apply mischief rule into modern interpretation. I will be dealing with the Indian cases in the next session. Thank you for listening to my lecture on mischief rule. Stay tuned until then.